Hello, this is Todd Whitlow. I'm an attorney with Brownlee, Whitlow, and Praet here in Raleigh, North Carolina. We have offices in Raleigh, Charlotte, and Charleston, South Carolina, and we have attorneys licensed in North Carolina, South Carolina, and Georgia. I'm a partner with the firm. I've been with or in the apartment industry since approximately 2007, and our office is tasked with generally doing the annual review of the NAA lease for the National Apartment Association. We previously worked on and revised the Apartment Association of North Carolina's lease. And so this program is primarily designed for those individuals transferring from the AA-NC lease to the NAA lease in its most current form. Before we get started, I need to give some disclaimer to make it clear that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information in this report is for general information purposes only. Information in this presentation may not constitute the most up-to-date legal or other information. Viewers of this material should contact their attorney to obtain advice with respect to any particular legal matter. No viewer of this material should act or refrain from acting on the basis of information in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. Only your individual attorney can provide assurances that the information contained herein and your interpretation of it is applicable or appropriate to your particular situation. Use of and access to this presentation does not create an attorney-client relationship between the reader and the National Apartment Association or any contributing law firms. All liability with respect to actions taken or not taken based on the contents of this presentation are hereby expressly disclaimed. With that out of the way, I want to kind of lay out the roadmap for where we're going to go today through this webinar. The goal is to provide users of the AA-NC lease with an overview of the NAA lease, but I think there's also some benefit to this program for current NAA lease users to the extent they want to get familiar with the lease and all of its content. We're going to highlight some of the prior areas of distinction between the AA-NC lease and the NAA lease, and show how those concepts have been blended to close some loopholes that may have previously existed. And then we're going to briefly review the addenda to the NAA lease, explaining what each of those are for and what they are designed to address and how they do so. With that being said, I think we can jump right in. I'm going to go basically, as opposed to paragraphs of the lease, I'm going to jump from page to page in obviously numerical order, but we're going to go over highlights of those respective pages to kind of hit on the few areas that you should pay attention to. Obviously, on the first page of the lease, we've got parties to the lease. Those are the owner, those are the residents, those who are going to be responsible under the lease agreement. In addition to that, there's an area designated for occupants. Those would generally be anyone under the age of 18, depending upon the policies for your property. We revised this particular section. It previously indicated that no one may reside in the premises on more than 2 consecutive nights or four such nights, I think, during a relevant month. We've kind of closed that obligation for you to show how many days someone has been in the premises, and basically set forth that no one else may occupy the apartment without your express written permission. What that means in proving something like an unauthorized occupant is that you can show, based on the circumstantial evidence, all of the information that you can gather, whether or not that person is more likely than not to be residing in the premises without your authority. You don't have to prove the number of days that they've been there. It's just kind of a general consensus that they appear to be living there. In addition to that, on page 1 of the lease is obviously the lease term. That is the length of the lease, the beginning date and end date. What is relevant and what's worth making note of in this particular paragraph of the lease is that we made some revisions to it as part of the blending process from the AA-NC lease to the NAA lease, so that now if the lease renews automatically on a month-to-month basis, if no one provides the written notice required, which is normally 60 days written notice prior to the end of the initial term, then the lease automatically renews on a month-to-month basis. and thereafter it would require 30 days written notice to non-renew the lease. The NAA lease used to be silent on what notice was required once the lease went month to month. And in North Carolina, it was important to put in special provisions that you were going to require at least 30 days written notice if you wanted to require that notice, because otherwise the tenant could default to a statutory notice period, which would have provided for 7 days notice on a month-to-month lease. So now we've closed that window, and all residents would be required to provide 30 days written notice once the lease goes month to month. In addition, on page 1 of the lease, you're going to find the provisions related to the security deposit, setting forth the amount of the security deposit, where it's going to be held, as far as what banking institution, including the physical address of said banking institution. There's a keys provision, which simply sets forth that the resident would be provided a set number of keys. It makes it clear that to the extent the resident loses or misplaces a key, that they would be responsible for the replacement cost of it. And also on page 1 of the lease is one of the more essential terms, which are the rent and charges that will be set forth. This provision simply provides what we would likely label as the base monthly rent. For those people who are familiar using the AA-NC lease, you will make note that the NAA lease, one of the areas of distinction is it doesn't have a summary of provisions page, which is what page 1 and most of page 2 of the AA-NC lease are. And the one important distinction when it comes to rent and charges is that the AA-NC lease included a base monthly rent, blanks for additional rent, and then it totaled them all as total monthly rent. One issue that created with the AA-NC lease is that, in our opinion, from a legal standpoint, the safest approach is charging late fees, the 5% monthly late fee, on the base monthly rent only. And it's my understanding that there was some data entry issues with Blue Moon where that late fee might have been being applied against the total monthly rent, and it required users to go in and kind of modify the math in some instances. You don't have to worry about that with the NAA lease. The only thing that should be set forth in the blank under the rent is the base monthly rent, what they're actually paying for the premises, less any concessions. If there is additional rent, such as trash fees or pet fees or any other monthly charge that's being assessed to the resident, you can put that in your special provisions section of the lease, which we will spend some time going over. But you don't want to add that to the base monthly rent and then put that total figure in that blank. That blank should only be filled in with the base monthly rent. In addition, under the rent and charges paragraph, you will note that we made some modifications. Previously, I think the NAA lease provided just a blank for the NSF fee, and that was controlled by statute in North Carolina up until October 1st of 2019. That fee was limited to $25 regardless of what your bank may have been charging you for NSF fees that you were hit with. Gratefully, our legislature increased that fee to $35 to kind of raise to the standard of probably what your banks have been charging you all along. And so now, while yes, you can put $35 in that blank for any leases executed after October 1st, 2019, it wouldn't have addressed any leases signed before that. And so what we've done to revise it is it sets forth that the NSF fee is the amount that's set forth in the blank in this paragraph, or the maximum amount allowed by law as of the date the check is tendered. So if for some reason during the middle of the lease term, the legislature increases that $35 fee to $40, well, now, notwithstanding the fact that the blank says $35, you may assess that resident $40 in an NSF fees because that would be the maximum amount allowed by law as of the date the check was tendered to you. In addition, on page 1, in closing out page 1, is the utilities paragraph, which makes it clear that directly billed accounts, those accounts where the name of the resident is, where there's a contract between the resident and the utility provider, and we're not sub-metering those charges, the resident is required to remain and keep those accounts in their name for the duration of the tenancy. It sets forth that they need to have them set up in their name at or before moving in and taking possession, but also makes it clear that they need to maintain those accounts in their name for the duration of their tenancy. And should they fail to do so, it would constitute a default of the lease agreement. That now brings us to page 2 of the NAA lease. Again, we're going to highlight almost all of the paragraphs and try and summarize them in as a short statement as I can, while also providing some additional feedback beyond the PowerPoint. So leading out the page 2 of the lease is the insurance requirements set forth, and to the extent that you require liability and or renter's insurance, there are 2 separate paragraphs on that in that provision. One is for renter's insurance. That will be somewhat, you may label it as contents insurance, and the other is liability insurance, making it clear that the property's liability insurance is not providing coverage for the resident's acts, so that to the extent the resident invited a guest to their premises and they slipped and fell, somewhere in the premises, if that individual sued the resident in addition to the landlord's coverage would not extend to the resident. It makes it clear that they need to secure their own policy and would set forth the amount of said policy. There is also an insurance addendum that we will spend some time going over later in this webinar. It makes it clear that a failure to maintain those policies in good standing for the duration of the lease term and any renewal thereof would constitute a default of the lease, which allows the landlord to exercise any and all available remedies that they may have under the lease. That brings us to locks and latches, which is slightly different or a variation on the keys provision. The keys, just on page 1, set forth the number of keys provided, limited made clear to the resident that to the extent they lose the keys, they would be responsible for it. This one is slightly different. This one deals with the locks and latches to which those keys may go to. The resident agrees as part of the lease not to install any additional or different locks without your express written consent. And if they do, they're required to give you obviously those passcodes or additional keys or a copy of the key to those different locks. The resident further agrees that any of them may request a lock change, allowing the landlord to change the locks, but the landlord also reserves the right to provide other residents with a copy of the key in the absence of a lawful reason not to. In other words, if you're getting a request from a resident who's a victim of domestic violence and they're requesting the lock changes and provide you with a copy of the order demanding that the assailant stay away from the victim, you would be within your rights as a landlord in that instance not to provide the assailant with a set of the new keys. You can ban their access under North Carolina law, and you would in fact be negligent probably if you did not do so in light of the order restraining the assailant from the victim. That is an instance where there would be a lawful reason not to provide the other person with a key. This is also the first instance in which you see a special provisions section of the lease under paragraph, I believe it's either 10 or 11. This small set of blanks would allow you the freedom to add any custom provisions where you might need them, whether it's related to a certain property condition or whether it's related to some owner requirement. There's also, it's important to note, if you have something that's a little more lengthy or has a need for more verbiage, there is a long set of blanks at the end of the lease for additional special provisions in case you need more room. There's also, if you need even more room beyond that, there's a separate addendum which we will go over later on in the PowerPoint. In addition, on page 2 of the lease, there's a reimbursement paragraph. This provision mandates that the resident must promptly reimburse you for any damages they cause. Previously, it didn't limit the nature of the damages, but under North Carolina law, there's a statute, it's 42-10, which basically says that in the absence of a lease excluding this requirement, that in order to hold a resident responsible for damage to the premises, you have to show that the resident was somehow negligent in causing the damage. Usually negligence requires a full trial. You're not going to win or prevail on something called summary judgment, which is a motion hearing when you have a negligence standard. And so we revised this paragraph as part of the blending of the AANC and NAA leases to exclude the application of 42-10. What that means is that the resident is now strictly liable. They're responsible to the extent any damage is caused to the unit while they are in possession of the unit, whether it's by them, their occupant, or any guest, regardless of whether they were negligent or had anything to do with the damages. They are basically agreeing as part of the lease agreement that they are fully responsible for the damages to the premises unless they can show it was caused by you, the landlord. This makes it a little bit easier to hold them responsible for physical damage to the premises or any other damage to other units that may be around the premises. Then we move to paragraph, I believe it's 12, which is eviction and property left in the apartment. This allows you to terminate the lease or the resident's right to possession of the premises in the event of a default. It's fairly straightforward. It kind of lines up with the default paragraph of the NAA lease. It just makes it abundantly clear that in the event of a default, you reserve the right to file an eviction, wherein you will either terminate the lease or the resident's right to possession. Now it also includes the offer to release the personal property to the resident following the execution of a writ. By statute in North Carolina, in order for you to be able to dispose of any personal property left in the premises after the execution of a writ following an eviction, the statute requires you to offer to release the property to the resident. If you don't make that offer, it kind of puts you in legal limbo as to what your rights are in relation to disposing of any remaining property. As a result of that, we felt like it was just out of an abundance of caution, we include the offer to release the personal property as part of the lease agreement. It makes it clear that to the extent we execute a writ, we're hereby offering to release the property in the unit to you during the 7 days immediately following the execution of the writ, and makes it clear that if they don't make arrangements to get said property, you can dispose of it as you see fit. That brings us to page 3 of the lease agreement. Page 3 has some fairly decent provisions on it, including rent increases and lease changes. In case you were unaware, you may not increase the rent charged on the premises during the lease term, or you can't make any substantial lease changes, or what I would call substantive lease changes, until the initial term ends, with the exception of any reasonable rule changes. And when referencing reasonable rule changes, we would always advise you against making a rule change that includes any type of monetary charge to it as part of a violation of that rule. If you want to fine for something that's going to come with some type of significant penalty or even a nominal penalty, we're just of the opinion where it comes with money strings attached to it, that you've got to wait until the end of the lease or any renewal lease to put that type of rule in place. Otherwise, no rent increases or lease changes until the initial term ends. I would say the only exception to that would be if you have offered a concession, because the concession addendum actually provides for the right that if the resident violates the terms of the concession addendum or discount addendum or any other provision of the lease, you do reserve the right to revoke the concession. That would be the only change. And it's important to note that that's a revocation, meaning that the next month after the revocation, the resident would be required to pay market rent. But other than that, I don't know of any other significant lease changes that you can implement during the middle of a lease term. Delay of occupancy is another important area, especially for those properties that might be under construction and are doing lease up, or where they're fully leased. It provides that if there's a delay in the delivery of the premises to the resident, that the resident would be entitled to an abatement of rent during the delay, or they can terminate the lease. But those are their only remedies. Previously, the NAA lease did provide that those were their only remedies, but we blended some of the AANC lease language into the current version that's going to be rolled out, so that it makes it abundantly clear that you as the landlord are not required to compensate the resident for any moving expenses, storage expenses, relocation expenses, any other type of expense beyond their right to an entitlement of abatement of rent until they're put in possession, or they have the right to terminate the lease once you give them written notice of the basis for the delay and an estimate of when the unit may be ready. At that point, the resident has a time period under the lease agreement in which they can terminate the lease and terminate all liability under the lease. One new paragraph that we added to page 3 of the lease is the rental application paragraph. It was not previously included, and it now makes it clear, and this was another blend from the AANC lease agreement. It makes it clear that you as the landlord relied upon the representations in the application, and if they are false or deceptive or misleading as a result of either an omission or an outright representation, it makes it a breach of the lease. In addition to that, it also now provides that you reserve the right to check, and the resident consents to it, that you have the right to check criminal records of the resident or any occupant in the premises at any time. And that means at any time during the lease term or any renewal term, basically any time that you deem necessary to check it, that you can check it. I would advise you to be careful in exercising that right and make sure that you establish some type of standard policy in doing so to avoid any claims of discrimination in the enforcement or utilization of that right. Disclosure rights, which was always in the NAA lease, it allows you to share information about the resident or their rental history to law enforcement, governmental authorities, or for business purposes. In addition to that, I would tell you that you have the right to disclose that information after you receive a lawful subpoena, meaning a subpoena issued either by an attorney or an officer of the court directing you to provide that information. You would have the right to do so. And in fact, if you did not do so, you may be sanctioned by the court. Another new paragraph that was added on page 3 of the lease, which those AANC lease users are probably familiar with, is the common areas paragraph. And it will be in the new lease that is going to be rolled out as part of this transition. It defines the term common areas to basically include everywhere except for the premises. It includes all amenities and the remainder of the property and other than the premises itself. Makes it clear that the rental payments, this is extremely important as we deal with COVID-19. It makes it abundantly clear that the rental payments that the resident is paying are only in exchange for their right to use the premises and for ingress and egress to the premises, and that you reserve the right to close any amenity at any time. Now, admittedly, the NAA lease in its original draft format provided that type of language in the community policies, rules, and regulations addendum, but we felt it would be a benefit to kind of just bolster that, make it even more clear to the resident and include it in the lease itself. It also allows you to govern the use of the common areas, including banning use by the resident or their guests and trespassing those people, meaning guests who might be violating any rules or regulations in place for the premises. And it would make a violation of those rules and regulations governing the common area a potential breach of the lease agreement. That transitions us nicely to community policies or rules. This paragraph is solely in here to incorporate any community policies, rules, and regulations as part of the lease agreement, and it makes a violation of those a default under the lease. You'll see when we get to the community policies, rules, and regulations addendum that it includes specific rules and regulations for each of the amenities and also governs some of the actions of the resident as it relates to the premises. What we added in this particular paragraph as part of the revisions and the blending between the two agreements is a reference to any restrictive covenants that may be in place if it's a mixed use property or if it's a larger developmental scheme that may involve multifamily community, townhome, individually owned townhomes, or individually owned condo section, or single family for that matter, if it's part of a larger development. It may have some master restrictive covenants that apply to it, and it just incorporates those by reference as part of this paragraph and makes it abundantly clear that if the resident violates any of those provisions, that it would be a default of the lease agreement. That brings us to page 4 of the lease. This one, two important paragraphs that relate to default and summary ejectment are limitations on conduct and prohibited conduct. They would seem to be somewhat similar. I guess they are. The limitations on conduct are obviously is not an outright prohibition, but it's certain rules or restrictions on what a resident may be able to do. It places certain obligations on the resident related to the premises. Like I think it provides that you can't use candles in the premises, that no combustible gases or grills are allowed to be used. It regulates the conduct of balconies and patios and those types of things. Under prohibited conduct, this is probably something more akin to what you're familiar with the AA-NC lease agreement. We made some revisions to this paragraph as part of the blending of the two leases. It sets forth specific restrictions on the resident, occupants, and their guests, and it now includes a broader criminal activity prohibition along with bans on allowing anyone previously trespassed to visit the community. I mean, these are specific prohibitions on disrupting the business activities of the property, interfering with the peace and quiet enjoyment of other residents, basically threatening other residents, disturbing activity of any kind. Now it says criminal activity of any kind in or about the premises or the community, including but not limited to the drug-related charges that were already in place in the NAA lease. So it uses those as an example of criminal activity, but it restricts all criminal activity in or about the premises and in the community. In addition, on page 4, you're going to find parking regulations dealing with if there are what can be parked in the community, warning of towing, and those types of provisions. There's also a parking addendum, which sets forth a little bit more specific instances of issues dealing with parking. The addendum is primarily going to be used, though, when you have some type of restricted parking, whether it's assigned parking spaces or whether it's just a decal or a rear view mirror hanger type restriction that requires the resident to display that at all times when in the parking lot. Release of resident paragraph makes it clear that there are very limited circumstances in which the resident can terminate the lease prior to the end of the lease term. Those really are going to be limited, and they're not required to be set out in the contract, but those in North Carolina would be limited to an instance of requesting out of the lease when the resident is a victim of domestic violence or under the Service Member Civil Relief Act. One of those instances are primarily the only instances in which a resident would be released from their lease early in the absence of some type of reasonable accommodation request related to a disability where the resident was no longer able or capable of living in the unit or by themselves in the unit. There's also a military personnel clause. Different from the AANC lease, there is no Service Member Civil Relief Act addendum. There used to be one with the NAA lease, but that has now been phased out and replaced by revisions to this particular paragraph. Because in all honesty, with the Service Member Civil Relief Act, all you were required to do was to confirm that all parties will comply with federal law related to military personnel and the rights granted to them. That includes their termination rights. That's all you needed to set forth. Much of the other stuff may or may not have been enforceable under the Service Member Civil Relief Act. And so why include an addendum that just kind of creates redundancy, and instead we summarize it in this paragraph. Resident safety and property loss. It sets forth that the resident's responsible for their own safety and you don't make any representations or warranties as the landlord related to their safety. And it explains what happens in the event of a casualty loss. We did bolster this paragraph a little bit in addition to the repairs and maintenance paragraph that we're going to get to in a minute by making it clear that to the extent there's a casualty loss, unless it was caused by the landlord, and when I say a casualty loss, I mean one that's going to warrant that's basically substantial destruction of the premises in which the resident is living. As long as it wasn't something caused by the landlord, you are not required by law to provide them with an alternative premises, somewhere else to live. You would be required to abate rent so long as the resident wasn't responsible for the damage. If the resident was responsible for the casualty damage, you will see in the next, either on the next page or when we get to the maintenance repair obligations under the lease, that if the resident was responsible for the casualty loss, not only do you not have to provide them with an alternative living arrangements, but the resident is not entitled to abatement of rent either, because they are responsible for the lost rent as a result of their responsibility for the damage to the premises. Which brings us to page 5 of the lease, which the first paragraph that we're going to get to is the condition of the premises. It used to be that this paragraph simply referenced the inventory and condition checklist form and said that the resident was responsible for filling it out and returning it to you, and did not specify any deadline, which, in theory, it's intended to be utilized immediately upon move-in, so it can kind of report and document the condition of the unit and thereby avoid the resident from being responsible for damage that already existed when they moved in. When there was no deadline by which they needed to return it, you could get that document 7 days or 6 months after they move in, and who's to say what was accurate? So now we make it abundantly clear as part of the revisions and the blending that the resident is obligated to return the inventory and condition form within 7 days of taking possession of the premises. If they fail to do so, any damages not notated, they will be responsible for at move out. In addition, this paragraph places restrictions on what alterations the resident can make to the premises during their residency, which now brings us to the requests for repairs and malfunctions. As previously noted when we were talking about the casualty loss provision, this paragraph deals somewhat with that, as you'll see from the second bullet point. This one requires all maintenance requests to be submitted through the resident portal or in writing in the absence of an emergency. In North Carolina, we have a list of imminently dangerous conditions that are set forth by statute. If it's one of those imminently dangerous conditions, You cannot require the request to be in writing. You probably should make a point of instructing your maintenance technicians to document it in writing so that they create the work order for it, and then they can show that when it's been completed and what they did in response to it. But if it's one of those imminently dangerous conditions, it cannot be required to be put in writing. But otherwise, you're perfectly fine requiring them to put it in writing. In addition, this paragraph provides you with the right to terminate the lease where there is substantial damage to the premises, and that's regardless of whether it was caused by the resident or not. If the resident was responsible, they would be held responsible for the rent regardless of your right to terminate. If the resident was not responsible, if it was a hurricane or a tornado that blew through and caused damage to the unit or some substantial flood, then you would terminate it as of the date of the casualty, and the resident would only owe prorated rent through that date and would otherwise be required to vacate the unit. If you exercise this right and the resident fails to vacate the unit within a reasonably prompt manner, you can treat them as a holdover resident and file a summary ejectment action against them. In addition, this page sets forth the animals provision of the lease. It makes it abundantly clear that no animals are allowed unless approved in writing, and gives you, the landlord, the right to demand any animals removal within a time frame set by you. In other words, there's a blank within this particular lease provision that you fill in, whether it's 24 hours, 48 hours, 72 hours, whatever you want to put in that blank is the time frame within which the person would need to remove the animal. This page of the lease also contains a paragraph addressing when you may enter the unit and your right to access. It sets forth a particular list of circumstances under which you can enter the premises, whether the resident is home or not. It makes it clear that the resident's failure to allow access is a default. It was understood, I think, before that if the resident failed to provide you with the right to access the premises, that it would constitute a default, but it wasn't set forth in the lease. As part of the revisions that we made in blending the AA-NC lease with the NAA lease, we actually included a statement setting forth that a failure to provide access is a default of the lease. The entry access is broadly covered. The only thing it doesn't specifically set forth a right for is a spot inspection, where you're inspecting a unit for the specific purpose of determining whether the resident is complying with the lease agreement. That might be to check for an unauthorized pet or an unauthorized occupant. So just make note of that that's the only thing that it doesn't necessarily provide for. But otherwise, I mean, I think you're pretty adequately covered on your rights to enter the premises. And if you need to do a spot inspection, you can always do a filter change or something along those lines. In addition, paragraph 5 sets forth that the residents, to the extent there's more than one resident on the lease, so that if there's multiple residents, those who are responsible for the lease agreement, it makes it clear that they are all responsible individually for the performance of the lease, and that they are responsible for occupants. And what I mean by that, if you've got 3 residents who sign the lease agreeing to be roommates, you can hold one of them entirely responsible or all 3 of them jointly responsible, and it is completely within your discretion. That's what jointly and severally responsible means. This paragraph also points out that notice to one is notice to all, meaning that if you give notice to one resident, it is deemed to be satisfactory as giving notice to all residents. On to page 6 of the lease. This is the first instance in which we address replacements and subletting. I mean, it's fairly straightforward, provides that residents may not sublet without your express written consent, and lays out the procedure for changing roommates. It's got a specific kind of mechanism for changing the roommates and makes it clear that if the resident provides the replacement resident, only a reasonable admin fee is required, but the departing roommate will remain responsible should the new roommate default. There, you can use, there is a change of roommate addendum, and I'm paraphrasing because that may not be the exact terminology used to identify the addendum, but there's an addendum specifically designed to address a replacement of a roommate. It provides, and it's kind of within the landlord's rights, whether or not the departing roommate will continue to be responsible or not. The default is that the departing roommate would continue to be responsible under the lease agreement. So that if the remaining roommate and the new roommate somehow default on the terms of the lease, you would have an additional party from whom you could recover. Next up is responsibilities of the owner. This does not go into as much detail as the AANC lease did, and that's also true for any tenant obligations for purposes of maintaining the premises. The tenant's obligations are set forth somewhat in the limitations of conduct paragraph, as well as the request for repairs and malfunctions, where it requires and obligates the resident to maintain the premises in a clean and sanitary condition, requires them to properly dispose of trash, all those types of things that you may have seen previously set forth in the AANC lease in a heading entitled Tenant Obligations or something along those lines. In addition, the owner responsibilities are not as itemized, and you don't have to. There's no reason to put those in the lease agreement where you're already required to do those things by statute. And this particular paragraph in the NAA lease agreement is sufficiently summarizing on a broad spectrum the owner's obligations as it relates to the premises and common area. I mean, these are basically responsibilities that are reflected in 4242, which is the warranty of habitability paragraph of the Residential Rental Agreements Act. It also mandates that you keep the common areas safe and comply with building codes. All these things are already set forth in 4242, and you're already required to comply with building codes. So, I mean, I think it adequately sets out the owner's obligations as it relates to the premises and the common area. Now it goes in and asserts what a default by the resident looks like. It specifies that the resident is in breach of the lease if they violate any terms of the lease or addenda. That's a giant net that's cast around the resident that provides an avenue for a default if you need it. And then it provides a non-exhaustive list of examples. And what I mean by that is that you will see that it lists approximately 10 to 13 examples of a default, including a violation of the prohibited conduct paragraph, a violation of the limitations on conduct paragraph, criminal activity of any kind, failure to timely pay rent. It lists all these things, but it's important to note that those are not the only mechanisms by which you can declare a default under the lease agreement, because they are just being used as examples. The lead-in sentence says it's a breach of the lease if they violate any terms of the lease or addenda. That's your broad scale. The list is just designed as examples and not as these are the only defaults of the lease for which you can exercise your rights. The revisions made as part of the blending project now make it clear that you can accept full payment of rent and proceed with an eviction for criminal conduct. That means you can accept a full payment of rent even after you know that the resident has committed or been charged with a crime of some sort. This paragraph also offers the release of personal property left in the premises following an eviction to the resident. As you'll recall, that was also in the summary ejectment or eviction paragraph. We put it in here twice just to kind of make sure that we were adequately putting the resident on notice. It also addresses remedies available to the resident or to the landlord if the resident holds over. That includes in essence, a markup in rent. It also includes a default of the lease and a summary ejectment or a termination of their right to possession of the premises. And it makes it clear that if the resident sign a renewal, and this is important to note because I think this is a fairly recent revision. It's not part of the blending revisions, but it is a fairly recent revision. This renewal paragraph makes it clear that if the resident had already signed a renewal lease, but then between when they executed and the beginning of the renewal lease, they default in the provisions of the current lease, that any termination of the current lease also effectively terminated the renewal lease. Which brings us now to page 7 of the lease. It's got a paragraph stating that no authority to amend unless in writing. This is fairly straightforward, but it puts the resident on notice that unless you and the resident agree in writing and execute or sign that amendment, that no amendment is enforceable against you, or that no amendment is effective for purposes of amending the lease in the absence of it being in writing and signed by the parties. The no waiver paragraph is kind of legal boilerplate, but it makes it abundantly clear that your failure or delay in enforcing any provision of the lease is not to be constituted as a waiver of your right to do so, or your acceptance of any partial payment does not constitute a waiver. The notice paragraph, we did revise it to include electronic signatures and authorizes electronic or facsimile notice, and that includes text. It states that the resident waives notice unless required by statute. It's worth noting that if you wish to file a summary ejectment, there is a requirement that's on the complaint for summary ejectment in North Carolina that says you've made a demand upon the resident for possession of the premises. And so that's an instance in which there is a statutory demand to do so. So it would be recommended that you send some form of notice, even where the lease says, in the event of a default, you can terminate their right to possession or the lease with or without notice. The miscellaneous paragraph, it's got basically some legal boilerplate in it. It includes a variety of provisions covering broad topics like making a lease subordinate to any mortgage, making it clear that no employees or agents are personally liable under the lease agreement or for any actions in the course and scope of their employment. It includes an eminent domain provision stating that to the extent any portion of the property is claimed as a result of eminent domain, including any premises rented by the resident signing the lease, that they are not entitled to any portion of the reward or the award for the eminent domain taking, and that you reserve the right to terminate the lease to the extent that the premises loses all of its value. In addition, now that we included the email or electronic mail, facsimile, and text notification, we needed to put a contacting you paragraph in here where the resident is allowing for the electronic notice via email and text, making it clear that those communications are not solicitations or cold calls, and that the resident is consenting to them and the receipt of them. There's an obligation to vacate paragraph stating that if they provide a move-out notice, which has been accepted by you, and that can be either party providing the move-out notice, the resident is required to vacate on or before that date. They cannot modify the move-out date without your written permission to do so. The force majeure paragraph that follows, some folks have tried to use in response to COVID-19, and when I say folks, I mean tenants, in an attempt to terminate their lease agreement. It is worth noting that this paragraph is only applicable to the landlord and the landlord's inability to perform the lease agreement as a result of war, pandemic, demonic, an act of God, or something along those lines. It is not applicable to residents' inability to perform the lease agreement. And then it's got a payments provision, which allows the landlord to apply payments to any outstanding obligation other than those prohibited by statute. And we made this paragraph a little clearer in the revision so that it clearly excludes this application of payments provision to any previously charged and uncollected late fees or sub-metered utilities. Those are prohibited by statute. You cannot take a current rental payment and apply those or apply it first to any outstanding late fee or sub-metered utility in an effort to create a shortfall in the current month's rent. There is also an association membership paragraph. This is a representation that the owner or management company is a member of the National Apartment Association, which would entitle them to use of this lease agreement through whatever the license agreement is that they have with Blue Moon or the local affiliate. It would make an unauthorized use of this lease, in essence, a breach by the landlord or the owner. It would, in addition to that, be presumably a copyright violation. Next, we have the move-out notice. This requires written move-out notice, and it must be provided within the time limit set forth in paragraph 3 of the lease. Paragraph 3 of the lease is generally going to say 60 days prior to the end of the lease term. And as we noted when we were reviewing page 1 of the lease, it now provides that on a month-to-month basis, 30 days notice is required. A termination notice from one resident applies to all despite any conflicting notices. This is one revision that we made to this paragraph, so that if you have 3 residents living together, 1 or 2 wish to renew, but 1 wishes to terminate, and 1 gives you the termination notice while you get a renewal notice from the other 2, the effective notice or the controlling notice would be the termination notice. And if the 2 remaining residents wish to continue to reside there, they will need to apply and sign a new lease agreement. Trending then down after they provide the move-out notice, it sets forth the move-out procedures for them. It makes it clear that the move-out date cannot change without your written permission. That kind of goes in line with what we talked about before, an obligation to vacate. That in essence, once that move-out date has been provided, you have relied upon that as a landlord in marketing the unit and possibly securing a new resident. And so if that new resident is scheduled to take possession, any delay in the current resident vacating would obviously delay you in putting the new resident in possession. So it requires that move-out date to stay the same in the absence of your written permission. The revisions included a requirement for written authorization from the resident to dispose of any personal property. Previously, this was not provided for as part of the blending project. We included an obligation by the resident as part of the move-out procedures to sign a written statement, and that can be in an email or it can be, a handwritten note signed by the resident. But you would want something signed by the resident, basically authorizing you, the landlord, to dispose of any remaining personal property after they surrender possession. So once they have informed you that they've vacated, they've turned in keys, and they've moved. If they had left any personal property in the unit and didn't inform you of it or didn't sign a written authorization for you to dispose of that property, historically, the abandonment statute in North Carolina is somewhat worthless because it's too hard to meet the requirements of it. And so that would have then required you to file a summary ejectment action for miscellaneous personal property being left in the unit, because that's the only mechanism that would allow you to otherwise dispose of that property liability free. So this provision in the lease agreement puts the resident on notice that they need to provide this written authorization, or if they fail to do so and leave any personal property in the unit, they would continue to be responsible for the monthly rent until you're actually put in possession of the unit, which means that you have the authority to dispose of that personal property. Page 8 of the lease includes a cleaning requirement. It requires the resident to thoroughly clean the premises before vacating. Makes it clear that if you don't do so, there may be some damages, especially where the cleaning is beyond normal wear and tear cleaning. There is a move-out inspection. This is not an obligation. It simply recommends that the resident meet with management to complete the move-out inspection. In addition to that, it makes it clear to the resident that any representations or statements made during the course of that move-out inspection are not binding upon the owner or the management company, as they are not final. They are not a final determination. You don't want a leasing agent or a maintenance technician who's uncomfortable with confrontation doing the move-out inspection and telling the resident that everything looks fine to me, and then you go upon further investigation, you find, pet urine or something along those lines, and now the resident's telling you, well, your employee told me everything was fine, I would be getting my deposit back. This paragraph and this language makes it clear that any statements made during that move-out inspection are not binding or final. And then the security deposit deduction paragraph, this basically just recites 42-51. North Carolina, we've got a list of 8 things that you can charge the security deposit against, and this paragraph just mirrors those 8 things. There's a deposit return, surrender, and abandonment paragraph. It requires the resident to provide a forwarding address and provides that where there are more than one resident. This is a revision that we included as part of the blending project. To the extent that there are more than one resident on the lease, that you can send a disposition refund to any single resident, and it's up to the residents themselves to divide it. You're not liable to the other 2 residents. Say if you had 3 roommates and you just sent it to the one that gave you a forwarding address, it would be up to the residents to divide that security deposit up. It also defines surrender of the apartment, which is what triggers the obligation to process the security deposit. And then we find the signatures. And now includes, and this is part of the revision, as I said before, in the notice section, we now include email and text authorization as far as notices go. The signature block now includes an area for the resident and for the property to include a cell number and an email address to which you would like to receive notices. And it also provides an area for the broker's license for the management company to the extent that's applicable. As I told you before, when we were reviewing the special provisions paragraph on page 2 of the lease, at the end of the lease, you will also find additional blanks to make any custom modifications needed for your policies and or property. And these blanks would be used where you have more extensive revisions that are needed. Those are all of the lease. Now we're going to transition to pre-lease forms. There's really only a couple of these. This particular section will go fairly quickly, especially considering that you're probably fairly familiar with the types of documents that we're going to be going over. The first one is a rental application. The rental applications for residents and occupants. Obviously, you wouldn't have occupants fill out the application, but the resident is going to list the occupants that are residing in the apartment with them as part of the application process. It is generally a basic application. It's no different than what you probably are familiar with AA and C for those users who are transitioning over. And so it is fairly straightforward. There's also a supplemental application for non-US citizens. It asks for additional information to confirm the resident or applicant status. It is only used to the extent the applicant answers the rental application for residents, indicating that they are a citizen of another country other than the US. And it asks a series of questions related to how they are in the United States some identifying information. It is worth noting that some jurisdictions object to some of the questions that are asked on the non-U.S. citizens application because they are not asked to all applicants. There's some debate about whether or not it's a national origin discrimination. We are not of the opinion that it is, but it is worth noting that some jurisdictions have taken that tack. In addition, there's a guarantor pre-leasing application. To the extent that you are requiring the resident to provide a guarantor for their performance of the lease, you would have the guarantor fill out this form. It seeks information qualifying the guarantor, including identifying information, address, assets, debt obligation or income. And then there's the supplemental application for units under government regulated affordable housing programs. This would obviously only be used where you have units or a property participating in an affordable housing type program. It includes additional obligations as far as answers of the resident goes and what they need to show in order to qualify for such housing. Like I said, those are it. I mean, you've got a application, a supplemental application for non-U.S. citizens, a guarantor pre-leasing application, and then a supplemental application for those participating in government regulated affordable housing. That brings us to the bulk of the lease package, and that would be the addenda that are signed with the lease. Some of these aren't always going to be signed. It's going to be dependent upon the property itself, but where it's applicable to the property, it would need to be signed with the lease package. So when the lease itself is signed. You have your crime and drug-free housing addendum. This one should be utilized, I would imagine, at most properties. It extends the definition of common area to include a much more expansive area, including other dwelling units in which criminal activity is prohibited. It makes it abundantly clear that criminal activity of any kind is prohibited in the common area and community. And it makes it clear that a criminal conviction is not required in order to show a default of the addendum and release. I think that's important to note because some people can get hung up where you get hung up on screening criteria where you can't consider criminal arrests. And for some reason, people then extrapolate that to, okay, if I can't consider it as part of a screening criteria, can I consider it when issuing a default notice? And the answer is yes. You are not required to wait for a criminal conviction in order to terminate a resident's possession or rights or anything along those lines, because it's a different standard of proof. If you have where you have a criminal arrest, in order to get a conviction, you have to prove beyond a reasonable doubt, which is somewhere around 98, 99% more likely than not that the resident committed the crime. From a civil standard, to show a breach of contract, all you have to show it was more likely than not, meaning that it's 51% likely that they committed the crime. And that's even if they aren't arrested or charged with a crime. Lease addendum for intrusion alarm. This addendum would only be used where the apartment is equipped with an intrusion alarm. I suppose you could use it if the resident is adding their own intrusion alarm, but it is primarily designed where the unit is equipped with an intrusion alarm. It puts the resident on notice that they are still responsible for their own safety and that the intrusion alarm is not a guarantee of their safety. It explains if a permit is required by the local municipality to operate the equipment for the intrusion alarm and whether they need to use a chosen alarm company or one of their choice. It further requires that if there's an access code to be provided to management, it needs to be provided to management, and puts resident on notice that no warranties are being provided. So in other words, it explains to the resident that there is no warranty that the security system is going to guarantee their safety, that they still need to, that they are responsible for their own safety and they're responsible for the use of the intrusion alarm. A mixed use addendum. This addendum would only be used if the apartment community itself is a mixed use community. You get more and more of this in North Carolina lately, especially in your more urban areas. This is where the apartment is located within a community where the ground floors may be retail, restaurants, or bars, or they're in the immediate vicinity and same streetscape as the apartment community. The purpose of this addendum is to put the resident on notice that they're choosing to live in a mixed-use community where there may be noises, vibrations, sounds, and smells up to 24 hours a day from restaurants, bars, and retail. The resident acknowledges that they've conducted their own due diligence. In other words, that they've walked the community in some way, fashion, or form, or visited the unit to see what noise levels are and determine that they are comfortable with them, and that as such, they are assuming the risk of living here, and they may not assert at any point that they're entitled to an abatement, a constructive eviction, or anything along those lines if it relates to the noises, vibrations, sounds, and smells of the businesses located around the premises. The construction addendum, again, this would be a limited use addendum. It would only be used where the property is under construction or there's planned renovations. It would need to be signed at lease inception because the resident is giving up some rights. It needs to be signed at lease inception because you want to have adequate consideration for the agreement and the mutuality of obligations under the agreement, so that if you tried to have the resident sign it after the lease was signed and you are going to be undergoing some type of renovations, the resident could refuse to sign it, or you might have to offer the resident some additional compensation or consideration, whether it's a monthly discounted rent to get them to sign it, but you would need to offer something in exchange for their consideration. Whereas if you have them sign it at lease inception, the consideration is all the other stuff that you're providing under the lease agreement, such as the right to live in the property and to get to and from the property. That's why you would sign it at lease inception when you know that there is construction or there's planned renovations. The purpose of the addendum is to have the resident acknowledge that they've been informed of the construction project and the likely disruptions it may create, including possible closure of amenities or unopening, where if it's a lease up and it's brand new construction, the resident could certainly move into the first phase and none of the amenities are open. And this puts them on notice that those amenities may in fact not be open or subject to use. The reason you need consideration for the agreement is the next bullet point, is because the resident releases the landlord from any claims related to noise or closure of amenities related to the construction. And it further explains rights if there is a delay in possession. And the delay in possession would simply entitle the resident to either the right to terminate the lease or an abatement of rent until they are actually put in possession. Brings us to the utility and services addendum. This addendum goes into further detail. We talked about the utilities paragraph being the bottom of page 1 of the NAA lease. This document will be used in combination with that paragraph, and it should be executed at lease inception or lease signing. And it goes into further detail regarding how the utilities are set up. That would be setting forth the ones for which the resident is responsible for directly, and those that will be sub-metered, and for the ones that are being sub-metered, what charges or administrative fees are being issued related to those sub-meterings. And then it would also set forth whether the landlord was providing any amenities at no cost to the resident, such as, if the internet was provided as a resident benefit. It further explains obligations of the resident to pay such utilities as they are invoiced or billed, and explains that failure to keep the account in the resident's name is a default of the lease, which would allow you to terminate the right to possession of the premises. It limits the liability of the landlord for any disruption in service. So unless it's caused by your gross negligence or intentional misconduct, for example, like a self-help eviction of some sort, you are not responsible or liable for any disruption in service. The mold information and prevention addendum, this is one that I don't believe is offered or that was included in AANC's addendum or addenda package. The purpose of the addendum, and this would be signed by any property to the extent you wish to use this addendum, the purpose of it is to educate the resident about mold while also obligating them to take certain actions. It requires the resident to keep the premises clean, wipe down, or remove any visible signs of moisture, mold, use exhaust fans appropriately. Those will be exhaust fans in the bathroom when showering, the exhaust fans around the stove elements when they are boiling water in an open pot. Maintain proper air circulation through the use of the HVAC system. That would include an obligation to try and keep the ambient air in the apartment below 80 degrees. And it requires the resident to provide notice to you of any water intrusion issue or malfunction in the HVAC system so that you can timely address whatever the circumstance may be. Failure to follow the requirements of this particular addendum is a default of the lease agreement, which would again allow you to exercise any and all available remedies under the lease agreement. A lease addendum for remote control card or access gate. Obviously, this is only used for those properties that have a remote control card or access gate for the premises, whether that's to access any parking facilities or the building in general. It would be executed at lease signing because it includes provisions that you're going to want to include as part of the lease agreement. It sets forth that the resident's going to be provided with a device at move-in and is responsible for safeguarding it. If it's lost, it sets forth the fee that they're going to be charged for the replacement. And it's important to note that notwithstanding the fact that you may put a fee into this addendum that the resident is responsible for, keep in mind that if the resident fails to pay it or fails to return it at move-out, and that's in the instance in which they incur the charge because they failed to return it, be mindful in that if you're charging them more than the card or access system or remote control actually cost you, that you should not be charging that blank flat fee towards the security deposit, because by North Carolina law, you can only charge the resident's deposit for your actual damages. That would be the amount that you're actually incurring as a result of having to replace that key. It mandates that the resident follow the written instructions related to use of the gate system, and that is not a guarantee of safety. And it explains that the landlord has the right to remove any access gate or system that might be in place in their discretion without any further notice to the resident. Lease contract addendum for enclosed garage, carport, or storage unit. Again, you would only utilize this addendum to the extent that you're offering that and the resident is agreeing to rent such a space. If the property offers a garage, carport, or storage unit and the resident secures one, then obviously this would be used and it would be signed at lease inception. It sets out the deposit and the monthly rent for the space or storage unit. It sets forth any use restrictions as to what the space, unit, or garage can be used for. One important addition that was added a number of years ago that I think is always worth noting, most of the time that they're renting a garage unit that has electrical outlets in it, that historically ties to the property's electric bill. And there were instances in which a resident may have been charging an electric vehicle as through that outlet. And obviously that was driving the property's electric bill up more considerably than it otherwise would. And so we put a provision in to this particular addendum, making it clear that any outlets in a garage are not to be used for charging electric vehicles. We revised this document slightly as part of the blending project to make it clear that to the extent the resident to the extent you evict the resident and you get a judgment for possession, terminating the resident's right to possession of the premises, that right to possession then extends to any space or garage. So to the extent that they leave any personal property in the garage after you execute a writ, you wait out the 7-day period after having offered to release the property to the resident, you can then dispose of any personal property left in the premises or in the garage, including any space that may have otherwise been used for storage, or a carport. To the extent the resident leaves a car parked in there, you have the right to have it towed once you go through the process of getting a judgment for possession and execute the writ and wait out that 7 days after having offered to release the property. Resident parking addendum. We talked about this briefly when we went over the parking paragraph in the lease. This addendum would be used if you have restricted parking in the community, meaning you either have assigned spaces or you have a decal requirement so that non-residents are not allowed to park anywhere other than guest spaces or visitor spaces, so that not to tow them. It includes a term for the parking addendum. This term would obviously coincide with the term or length of the lease term. It includes rules governing parking lot use, allows for specification of an assigned space if needed, and warns of towing at residents' expense for any violations of the rules or use restrictions. It then identifies the cars being used by the resident and any occupants, and allows you to remove the vehicle should the resident fail to do so following a lease termination. This language that I'm referring to mirrors the language that's in the carport, storage unit, garage addendum, wherein the definition of premises is extended to any assigned parking space, in the event that the resident has their right to possession terminated through a summary adjustment proceeding. Lease addendum liability insurance required. This is obviously used where the property requires liability insurance to be carried by the resident. It makes it clear that the property policy is not covering the liability of the resident, and they must secure their own coverage. This just kind of feeds into the insurance paragraph that we talked about at the top of page 2 of the NAA lease, and just kind of further drives home the point. It also sets forth the amount of coverage that they must provide, and that the resident is required to maintain said policy for the duration of the lease term and any renewals of the lease term, and failure to do so will be a default of the lease. Community policies, rules, and regulations addendum. I know that some properties or some management companies have their own version of this form. To the extent you do not have any community policies, rules, and regulations, and you wish to utilize these, then in that instance, you would have this document signed with the lease package. It sets forth the rules and regulations for the community. It governs the common area and amenities in much further detail than the lease. It sets forth that the resident is using those areas at their own risk, and that they are assuming all such risk. It includes the right of landlord to close any amenity without further notice of any kind. It sets forth rules for the pool, the fitness center, any package release program you offer, the business center, and parking. It also provides rules related to the premises regarding fire hazards exterminating services, drapes and shades, water beds, balcony and patio use, signs, and satellite dishes. And it makes it clear that a violation of this addendum is a material default of the lease. I think there are many instances in which residents violate the provisions of this particular addendum, and so it is of rather significant importance. The short-term lease addendum is not an addendum designed for approving short-term rentals where the resident is subleasing. Rather, it is used where the resident needs a short-term lease. In other words, the resident comes in to apply for an apartment, and they tell you that they basically only need it for 2 months, or they want to rent it for month to month, or some variation of that. You could theoretically fill out the main body of the lease and put in that the lease term is from May 1st to May 31st, but that's still going to have some conflicting language in it, because if you recall, paragraph 3 sets forth that 60 days notice is required prior to the end of the initial lease term. Well, you can't provide 60 days notice where the lease term is only 30 days in length. So this addendum modifies paragraph 3 of the lease, as well as the move out notice procedures. It is important to note, if you are utilizing this form for any reason, that under North Carolina law, if the term is less than 90 days, it is considered to be transient in nature, which means that you are responsible for paying a hospitality tax for the rental of that unit, and you would need to pay that for the 90-day period. If the resident, for whatever reason, remains in possession beyond 90 days, then you can cease paying the hospitality tax, but you would not be entitled to a refund of that tax. The taxing authority would simply tell you that you have a credit going forward for any instances in which you have to similarly pay it. You should consult with counsel as needed on this particular form, especially where the rental term is going to be less than 90 days. The addendum prohibiting short-term rental or subletting. This addendum was added, I think, to the portfolio or docket of available forms for the NAA lease package when Airbnb and VRBO and the like started popping up everywhere. If you, the property, wish to restrict short-term rentals or subletting by residents, this addendum would need to be signed at lease inception. It's designed to restrict rental, and more importantly, rather than rental, because it's very difficult to prove that someone is actively renting on Airbnb or VRBO, but it more importantly, it prohibits the solicitation and advertising for rental through businesses like Airbnb or VRBO or any other similar platforms. The solicitation and advertising is generally much easier to prove, because if you can identify the unit as being one that is within the community, then I think you can do some super sleuthing or detective work and determine which resident is listing it, and then send them a default notice, because it does set forth that a violation of this addendum is a material breach of the lease. Lease addendum for satellite dish or antenna. This is fairly similar to the addenda that is used for the AA-NC lease, or that was used. It can be signed with the lease package or when the resident requests a satellite dish. Either one is fine in this instance, because the consideration would be the approval of the resident's request to install a satellite dish. It allows the resident to install a dish and sets forth how many they can install, the location where it must be installed, and the manner by which it is installed. And when I say manner, I mean that setting forth that it can't be drilled or mounted in any way other than a clip. It must be mounted in a way not to damage the property. It must stay within the area to be rented by the resident so that it can't protrude out beyond the balcony. No wiring or other type of conduit can be run or drilled through the wall. Basically, no alterations can be made short of mounting the satellite dish using some type of clip or similar device. In addition, it requires the resident to obtain a specific liability insurance policy to cover claims related to the dish. It also requires a security deposit to cover any damage and the cost of removal of the dish should the resident fail to remove it at move out. And finally, it closes with the resident may not begin installation of the dish until the insurance has been provided, the deposit has been delivered, and written permission has been given by you, the landlord, which presumably would come by means of signing this addendum. Everybody's favorite, the animal addendum. I think one important thing worth mentioning as we review the animal addendum is that AANC users are probably familiar with the pet addendum. The one thing I would point out is that the animal addendum, just in and of its title, is better suited for all-around use, because historically, if you had a emotional support animal and you had them sign the pet addendum but did not charge the pet fee or the pet rent or the pet deposit, it still referenced the term pet in utilizing and setting forth all the rules. Well, as we know, under the Fair Housing Act, emotional support animals are not considered pets. That's why they're not paying a pet fee, pet rent, or a pet deposit. So, there was always a chance that if you demanded the emotional support animal to be removed, where it either demonstrated some level of aggression or if it was barking incessantly or something along those lines, and you cited a violation of the rules and regulations set forth on the pet addendum that referenced pets and restrictions on pets, there was always the chance that the resident could argue, well, this isn't a pet, it's an animal, and because pet is a defined term under that addendum, we're not required to comply with it, and they would have a decent argument. So that's a long way of me telling you that the animal addendum is actually better than the pet addendum because it uses the term animal throughout. And so any rules and regulations short of the deposit, the rent, and the fee are applicable to emotional support animals. It can be signed with the lease package or when the resident requests to have an animal. I think most folks have it signed with the lease package because it still documents where no animal is actually there, and the resident would sign it acknowledging the absence of an animal. It provides for things like the animal deposit, the animal rent, and a non-refundable animal fee, which is for the privilege of being allowed to have the animal. And then more importantly, it provides a description of the animal and lays out the rules related to having an animal in the community. Finally, it makes it clear that a violation of the rules set forth in the addendum could result in the demand to remove the animal or termination of the lease or their right to possession of the premises. To go along with the animal addendum, there is a support or service animal amendment to the animal addendum. It would be used, obviously, if someone requests a service or support animal and they were able to verify a disability and disability-related need for the animal. It makes it clear that the resident is not required to pay any fees related to the animal, but they remain responsible for any damages it may cause. In addition, it makes clear that they are subject to the rules set forth on the animal addendum, and a violation could still result in removal of the animal or termination of the lease. Even where it's an emotional support animal, if it's violating the rules and regulations, say they are walking it off leash and they continue to do so, or it's aggressive towards another animal, or it's barking incessantly to the point that multiple complaints are received about it. In that instance, this addendum allows you the right to demand the removal of the animal, even though it's an emotional support animal or a service animal. Just be mindful that the resident in question would have the right to replace that animal with another animal if you demand its removal. The inventory and condition form, we talked about this briefly when we were reviewing the lease, mainly making note that it now has a 7-day deadline for the resident to complete it and return it. It's a move-in checklist. It's given to the resident at move-in. This is not anything any different than what AA and C lease users are already familiar with. And it's important to note if no damages or issues are cited on the list, or if it's not returned, any damages to the premises noticed at move out would then be attributed to the resident. The bed bug addendum, it seems like bed bugs have gone down rather significantly since everyone was educated on them and knows what to look for, but who knows? We're also now dealing with COVID-19 and something called a murder hornet. So who knows what plagues will be upon us next. This addendum has the resident acknowledge that they've inspected the premises and their personal property prior to move-in and did not observe any bed bug infestations, and that they further certify that their current apartment did not have any infestation. It's important because if an infestation is ultimately later discovered, and then we go back to their prior landlord and submit some discovery and determine that there was a record indicating that there was a bed bug infestation at the resident's previous unit, we would then obviously seek to hold the resident responsible for any damages we've incurred, including cost of treatment or loss of other residents. And we would seek to terminate their right to possession because they would have lied. It requires the resident to allow access for treatment and inspection. It requires the resident to promptly report any evidence of an infestation. Beyond allowing access, it requires them to cooperate with treatment. Cooperation with the treatment protocol or plan could include removing their personal property from the floor, making sure that the unit stays relatively clean and clutter-free, at least through the infestation treatment period. It also contains, more importantly, educational information for the residents' benefit on page 2. It tells them what bed bugs are, that they're non-discriminatory when it comes to race or economic conditions. It tells you, to refrain from taking personal property from the curbside and being careful where you purchase it from through, whether it's Salvation Army or yard sales or anything else for that matter. The lease addendum for rent concession or other rent discount is used if the resident has provided a concession, obviously. It specifies whether the concession is a one-time discount, like first month free, or if it's spread over the lease term through monthly discounts, where you take a certain dollar amount, you divide it by 12, and then you take that amount off of the monthly rent for the duration of the lease term. It provides, in addition to that, some opportunity for creativity if you have a non-monetary concession of some sort. That could be anything as simple as an installation of a ceiling fan or some other non-monetary benefit of some sort. It informs the resident that if they default, the landlord reserves the right to revoke the concession going forward. We talked about this briefly. It is worth noting that this is not a chargeback provision. It is a revocation provision, meaning that you would simply revoke the discount going forward for the month immediately following the month in which a default occurred. Photo, video, and statement of release addendum. This would be signed at lease inception for it to be enforceable and to have consideration behind it. It's for use of video and images in social media, digital advertising, and any other form of media. It's very similar to the AANC form that those users who are using that lease will be familiar with. It's basically designed to protect you for those instances in which you post video or photos on Instagram or Facebook or TikTok or any other social media platform in which you have other residents featured, whether it's them talking, them just interacting, or them participating in whatever the social networking type event that you're conducting. Residents and occupants 18 or over should sign, and if there are occupants under the age of 18, I would recommend having the guardian or the resident under whose lease they're going to reside sign on their behalf. The no smoking addendum. Just as it sounds like, it's to be used when the property or a building is designated as non-smoking. It defines in the broadest way possible what smoking is and makes it clear that smoking is prohibited anywhere inside buildings in the community. It designates a smoking area to the extent there are any. There are some properties that are completely smoke-free where there is no designated area and the resident would have to step off of the property in order to smoke. But if you do wish to designate a specific area, you would set it out in this particular addendum. It makes the resident responsible for any damages associated with smoking, including lost rental income. But it also makes it clear that a violation of this addendum is a material default of the lease. But more importantly, it references that the addendum and the fact that it's a non-smoking community does not guarantee that the unit would be free of smoke. We can't guarantee other residents' performance, and we are required, if we have to evict them, it's going to require the residents' cooperation. Package acceptance addendum. This is to be used when the property offers and the resident elects to utilize the package acceptance service. Some properties charge a fee for this type of service. Others do it just as an amenity or a resident benefit. This addendum sets forth that the owner is agreeing to accept packages for residents during normal business hours while reserving the right to reject any package in their discretion. It does notify the resident that in order to retrieve a package, they would need to show a photo ID, and it informs the resident there's a blank that you fill in on how long you will keep their package before returning it. Finally, it makes it clear that you are not a safeguard of their property and they assume the risk of using the service. This is akin to making sure that the resident knows and that the property discloses that the offering of this service does not create what we call in law school a bailor-bailee arrangement, because especially where you charge a fee for this service, there could be an argument that there's a bailee for hire, and where that happens, you have additional obligations to safeguard the property. So by putting in here that the property is not agreeing to safeguard the property, the resident is using it at their own risk, it makes it clear that those obligations do not fall upon the landlord's shoulders. Addendum regarding medical marijuana use. This has limited benefit in North Carolina, but the purpose is to acknowledge that while there are some limited instances in which medical marijuana may be allowed under North Carolina law, which I still think is open for debate, but federal law is still treated as a crime. It basically tells the resident, in the absence of a disability that would require it, they are not allowed to use medical marijuana, and the community remains a drug-free community adhering to federal law. The surety bond addendum. This addendum is only signed if the resident elects to purchase a surety bond in lieu of paying a security deposit. It's fairly rare that this takes place, but to the extent that your property offers that as an option, you would utilize this form, and it simply makes it clear to the resident that the surety bond is non-refundable. It is not going to the landlord, it's going to the bonding company or the insurance company, and that the surety bond is designed to cover any damages to the premises caused by the resident. Washer and dryer addendum is exactly what it sounds like. It's only to be used when the resident is electing to rent a washer or dryer from you. It identifies the washer and dryer being rented by a serial number, I believe, and make and model, and sets forth the amount of the rental fee to be paid each month and makes that rental fee additional monthly rent. So if you wanted, you could set forth that amount on this addendum. You could also put it, the amount of the additional rent in the special provisions section of the lease. It makes it clear the resident is responsible for any damage to the washer and dryer or to anyone else's property as a result of their use of the washer and dryer, so that to the extent that they improperly use the washer and it overflows with suds and water, and then it gets into an adjoining unit, damaging that resident's personal property. The resident who rented the washer and dryer would be responsible for that and not the landlord. It does require that the resident provide access to the equipment for maintenance or repairs as needed, and the resident agrees to use the washer and dryer for intended household purposes only. The asbestos addendum, it will be used when you know or believe that the property was constructed using asbestos materials, which are still in place. It discloses the presence of asbestos and assures the resident that there's no risk or health concern unless the material is disturbed, which then sends fibers into the air, and it restricts the resident or occupant from disturbing or attaching anything to the walls, ceilings, floor tiles, etc. Any area in which the fibers are likely to be disturbed and dispersed into the air. Lead-based paint addendum is to be used for those properties built before 1978, wherein there's any concern that lead-based paint was used in construction. It serves as notice to the resident that the property was built before 1978 and that there may be lead-based paint on the property. It provides a great deal of educational information, all of which is required by federal law on lead-based paint concerns and exposure. And then there's a disclosure acknowledgement form along with a renovation form. The disclosure acknowledgement form would be signed by the resident and you, where the resident is acknowledging having received the educational materials. And the renovation form is obviously only used where you're going to be conducting renovations or remediation of the lead-based paint because those must be done in accordance with federal guidelines. Then we've got the lease contract guarantee. It is to be used when the resident is required to provide a guarantor and should be signed by the guarantor at or before the lease signing. It is important to have it signed before the lease is executed because in the guarantee agreement, it contains language indicating that you as the landlord relied upon the guarantee in entering into the lease with the resident. So obviously if it is signed after the lease is signed, that statement becomes somewhat problematic. If it is being signed outside of your presence, I would recommend to have the form notarized because you want to avoid circumstances in which the guarantor could allege fraud, alleging that the resident fraudulently signed their signature. And then the guarantor, in the agreement, the guarantor is agreeing to guarantee the resident's performance under the lease, and it requires them to be primarily responsible, not secondary. What that means is, short of an eviction filing, where you certainly would not name the guarantor as a party to the eviction filing, in any other circumstance, you can hold the guarantor just as responsible as you would the resident. So you do not name the guarantor in an eviction, but if you were filing a money owed action against the resident, you can name the guarantor in the same action. And you can recover it all from the guarantor or all from the resident. It does not matter. It's important to note that because there are instances in which you could have a guarantor who can assert a defense to you proceeding against them to collect the money by saying you have to first go after the resident and exhaust your remedies against the resident before coming after me. You do not have to do that with this guarantee. You can proceed directly against the guarantor and attempt to collect it. The guarantee is irrevocable for the duration of the lease term or any renewals thereof. So in essence, the guarantor is agreeing to guarantee the performance by the resident for as long as the resident is living there, and they are giving up the right to revoke that guarantee. The lease contract addendum for units in government regulated affordable housing programs. That is quite the mouthful. This is used when the property or any particular units at the property are participating in such programs. Those could be a home program, a low-income housing tax credit program, a Section 8 housing choice voucher, or any other similar situated program. It sets forth some additional regulations for compliance by the resident and property, including obligations to cooperate in the recertification process. It makes inaccurate information or the failure by the resident to update that information where either the number of individuals living in the home or their income changes and they fail to update it in accordance with whatever that program's requirements might be, that to the extent they fail to do so, it is a breach of the lease agreement. There's also for North Carolina a low-income housing tax credit addendum. This addendum is required by the North Carolina Housing Finance Agency in North Carolina, and they must provide it to be used when the property participates in the low-income housing tax credit program. It makes it clear that to the extent there's any conflict with the lease, the addendum controls, and it limits all non-renewals to those for good cause. Normally under the lease, we would tell you you can non-renew a resident for any reason or no reason. Low-income housing tax credit programs are one of the exceptions to that rule, and that program requires any non-renewals to be based upon good cause. And so that is set forth in this addendum and modifies the provisions of the lease agreement. It also places some additional obligations on you for accommodation and modification requests and responses thereto. It kind of sets a timeline for when you must respond and how you must respond. And then it also provides for periodic inspections of the unit. Those are all the addenda that are signed generally with the lease package, which brings us to those forms to be completed after initial signing. Some of these are piecemeal. In other words, they will only be used as the circumstances dictate, and others may be used in each instance, but always and most frequently after the lease has been signed. These are forms to be completed, again, after the lease is signed. They're used for modification of the terms of the lease, such as changing co-tenants or co-residents, a disability-related accommodation modification request, and any additional services that the property may provide, such as clubhouse rental, or if there's pool rental, or movie room rental, any other type of amenity that may be in existence that's allowed and open for rental. For tenant requested lease changes, the documents that are generally used is you have a lease contract amendment to add or change a roommate during a lease term. I referenced this briefly when we talked about subletting or changing roommates. It needs to be signed by all parties to the lease. So if you've got 3 co-residents and a landlord and one resident wants to leave, it's not just the landlord and the leaving resident that have to sign that amendment. All 3 residents and the landlord need to sign that amendment to make it enforceable. And if there's in addition to that, if there's a new roommate, so if you're not just dropping one off, if you're switching roommates, the new roommate would also need to sign that document. It literally needs to be signed by all parties to the lease. If there are new guarantors, then new guarantees need to be signed too, because it's modifying in some, I guess, it's modifying in some way their obligations and what they're guaranteeing. They're now guaranteeing a new person. This document also sets forth whether you're releasing the departing roommate from further obligations under the lease, or whether they continue to be responsible, whether you're dispersing the deposit and the new roommate is replacing the deposit, or if you're keeping the deposit, and it's up to those 2 roommates to decide what they do about it. Another form that is used after the lease is signed is the resident's notice of intent to move out. It's only signed by the resident until processed by the office. We recommend providing in the special provisions section, acknowledgement of receipt of this notice shall amend the lease to terminate your right to possession on the move-out date provided above. because there is a special provisions section in the notice of intent to move out. That way, it kind of specifies that the resident is agreeing to move out on that particular date. Now we get to a form that is frequently used and signed at lease inception, despite the fact that we regularly tell properties not to sign it at lease inception. The lease contract buyout agreement is specifically designed to be utilized when a resident comes in and says they want to terminate their lease early and they don't otherwise qualify for one of the bases to terminate their lease early. It gives them the opportunity to, in essence, settle their breach of the lease, because that's what it is to break the lease early, by giving a required notice and then paying a agreed upon buyout fee. If they signed it at lease inception, our concern is that it is unenforceable because it lacks consideration, and the Real Estate Commission here in North Carolina may view it, especially where the buyout fee is already set forth in it, to be a predetermined termination fee that is clearly a penalty in nature and is therefore unlawful. So if you want to put this in your lease package, I think that's fine for you to do so, but I would rather you not have the resident sign it and just inform them if a circumstance arises in which you need to terminate your lease early, this is the form that you would use. And you can either elect to continue to be responsible for the monthly rent until we find a new tenant, or you can enter into this agreement and kind of buy your way out of the lease. Reasonable accommodations and modifications request forms. There's a couple of them. The request for a reasonable accommodation modification is a simple request form for convenience of the resident. This is similar to what the AA&C lease also provided. It's important to note there in red, you cannot require the resident to fill out this form. You can suggest it to them to make it abundantly clear. Even HUD in their most recent emotional support animal policy statement encouraged the resident and the property to put any accommodation requests in writing so to avoid any miscommunications as to what was being requested, but you still cannot require it of the resident. If they don't want to fill it out, my suggestion to you would be to meet with the resident, pair it with them. In other words, say, this is what I hear you asking for. If the resident acknowledges saying yes, then write that in the form for them. Request for reasonable accommodations and or modification of the rental unit. It's a more detailed request form explaining what they need modified to the particular unit, but again, it cannot be required to be put in writing. And the reasonable accommodations and modifications request forms part 2, there's a verification form. This is to be completed by the healthcare provider as authorized by the resident. Again, be careful in requiring that they use this form. If the resident has a letter from their medical or mental health provider demonstrating the disability and disability related need for whatever it is they're requesting, you should not be making them fill out this verification form on top of whatever they provided. You would only utilize this form if what they provided was insufficient to verify a disability and disability related need. And then approval or denial of the reasonable accommodation and or modification request. It's a detailed explanation form of decision, whether to accommodate, modify, and the extent to such request is granted. It basically documents what you've agreed upon with the resident. It puts it in writing so that you can document the file. If there are additional requirements based on a modification request, it would be set forth in this form. There's also a policy statement that is included on accommodation and modification requests. We did not go over that form. It's not something that you would fill out. And because modification accommodation policies are mainly determined in-house from management company to management company or owner to owner, we did not go over that form. And that, ladies and gentlemen, summarizes the NAA lease and all of its addenda from a 35,000 foot view. We did not go into detail on every particular provision of an addenda. I tried to summarize what it did and what it is used for. Thank you for taking the time to listen to this, and please reach out to us if you have any questions or concerns.